You are mid-enforcement or mid-licensing with an issued patent, and a defect has just surfaced in the claims, specification, or drawings that severely limits what the patent can actually do. This explainer covers exactly which mistakes most often force a reissue and how to tell if an issued patent has one of them. Starting with the enforcement reality and thresholds for patent reissue. We apply a strict statutory threshold to determine if an issued patent is actually eligible for correction. People frequently ask, my patent already issued, can something still be wrong with it? The reality is that even after successful prosecution and formal issuance, a patent can still be wholly or partly inoperative. The boundary for what we can fix is strict. Under 35 U.S.C. Section 251, a reissue applies only when the patent is wholly or partly inoperative or invalid because of a defective specification, drawing, or claim scope. That strict statutory boundary directly answers the next question. Does a typo or small error in my patent qualify for reissue, or is that not worth pursuing? Plain typos and misspellings do not qualify on their own. The error has to fundamentally impact the scope or operability of the patent itself. Time is another massive factor here. You might be wondering, is there a deadline I need to worry about, or can I file for reissue anytime? The direction of your correction dictates your statutory deadline. This creates a sharp procedural split based on what you are trying to achieve. Broadening reissues face a hard 2-year filing window from the original grant date, with absolutely no extensions available under Section 251. Narrowing reissues, on the other hand, carry no fixed deadline, though waiting too long can seriously weaken enforcement against parties who relied on the original claims. Now let's look at fixing claim scope errors. Claim scope errors are the most frequent defect we see, forcing a reissue filing. You might find yourself analyzing a competitor's product and asking, my claims might be too narrow to cover what we're actually selling. Can reissue fix that? Claims drafted too narrowly leave your actual commercial embodiments unprotected. A broadening reissue can fix this, provided it is filed within that strict 2-year window we just discussed. But there is a significant restriction to expanding those claims. You might ask, what is this recapture doctrine I keep hearing about, and could it block my reissue? The recapture doctrine acts as a strict barrier to expanding narrow claims. Tested through a 3-step analysis under MPP Section 1412.02, the recapture doctrine stops the patent owner from using reissue to take back claim scope that was deliberately given up to get past a rejection during original prosecution. This is vital to understand. It blocks recapture even when that surrender only happened in an argument and is never explicitly written into the claim itself. Vulnerabilities aren't limited to independent claims. Dependent claim errors, like a missing antecedent basis, logically impossible narrowing limitations, and scrambled numbering introduced from late-stage amendments, also severely impact claim enforceability and warrant correction. If you want the full 5-step prevention sequence we run on every application before it ever reaches the examiner, the full article is linked in the first comment below. Let's transition to specification and drawing defects. Beyond the claims, the written description and figures often harbor enforcement-killing gaps. If you try to fix those gaps, you face a hard limitation. Adding detail through reissue is allowed only when it was implicit in the original filing. Title 37 CFR Section 1.73 strictly blocks anything that counts as new matter. When visual elements fail, it usually comes down to 3 critical drawing defects that routinely force reissues. These are missing views of claimed features, reference number mismatches between the specification and figures, and inconsistent embodiment depictions that leave the scope of protection entirely unclear. Moving on to correcting inventorship mistakes. Naming the wrong inventors is a serious defect, but it does not always require reopening the entire patent to examination. A frequent procedural question is, if it's just an inventorship mistake, do I need a full reissue or is there a faster fix? The procedural path for correcting inventorship depends entirely on consent and claim scope. Inventorship errors go through a certificate of correction under 35 U.S.C. Section 256 when every party agrees and no claim scope changes. However, a full reissue is required when the correction is contested, when the assignee files without consent under Section 118, or when it's bundled with a claim scope change. Finally, let's cover the pre-filing prevention sequence. The difference between a solid patent and one requiring a complex reissue traces directly back to pre-filing scrutiny.
Proactive measures change the outcome entirely. We apply an examiner-level review sequence before filing to cross-check explicit term support, verify antecedent basis, confirm drawing structural references, flag late surrender generating amendments, and deeply review priority claims.
Most reissue cases trace back to claim scope, specification support, or drawing consistency problems that a careful pre-filing review would have caught. If you're looking at an issued patent and something about the claims or drawings doesn't sit right, the full breakdown of what qualifies for reissue and what doesn't is in the first comment below. Subscribe to this channel if you want ongoing, authoritative patent and USPTO guidance delivered directly to you without having to search for it each time. After all, if your most valuable patent faced an examiner's scrutiny a second time, would it survive?